Well, hello, I'm Amy Rose Herrick, and we're going to talk about estate planning basics today. Now, I want you to first understand, I think the best planned estate has absolutely nothing in it. Now, think about that. I really believe in having an estate that, well, there's nothing, absolutely nothing that we need to probate. So there's nothing for a creditor claim to get. We have already handled the distribution of our estate. It is not a public affair because it's all been taken care of. Don't need the courts. So that is my goal, is to try to look and see how many estates can we get to where we really don't need the probate process because we've handled all of the issues. So I've got 5 main goals for you today, 5 of them. Now, the first goal is going to be, I want you to listen and I want you to learn. Now, my second goal is I want you to seek advice and I want you to secure qualified, competent counsel. Now, the third one, we're going to articulate what some of the issues are and we're going to prepare for how we're going to handle those. And then we're going to do follow-up and we're going to update our estate plans. Fifth one, best one of all, we're going to enjoy life. And we're not going to have some of these issues out there that, keep you awake at night or just leave that unsettling feeling within. Now, the other thing I want you to know what? Knowledge, it's power. And I'm going to empower you today with some of the knowledge we're going to share. Now, I want to talk to you about the word steward and how I define steward. Now, when I define a steward, it is, you could say, you are managing or looking after another person's property. It could be on a very public, it could be at a private. You are supervising arrangements. You're keeping things in order. The event was organized and stewarded the property. So they took care of it as if it was their very own and that standpoint. So we're going to think about a steward. Now, when you are a steward of all of the resources that you have, there's really just 2 types. I see a reactive steward. You only act when something is on fire. It's an emergency. You have to deal with it, and you've got to rush to deal with it, so you don't always make some of the best decisions. Usually costs more. What if you're a proactive steward? Now, that's what I really want you to be, as a proactive steward. Now, proactive steward has the opportunity to look at all the options and to implement that option that is absolutely best for you and for your family. And the other thing I have said many times, after all, it's only money, yours. And when anybody starts saying the words, it's only money, they usually want your money. That's what's behind that phrase. Now, let's really be honest with each other. Who are you right now? Are you a good and wise steward of your resources? Are you wasteful? Are you uncaring? Really, there's just the 2 different types. Now, going forward, because we cannot change yesterday, let's talk about who you want to be as a steward. Now, do you want to be a good and a wise steward, even in death? Or do you want to be wasteful, uncaring? You don't care what happens when you're deceased and leave your estate in disarray. And it costs everybody more money. And all that work you built in order to build it up, well, we're going to lose a lot of it in fees and expenses, and it's going to take a long time. But hey, if that's the legacy you want to leave, don't change a thing. Now, one other thing I want you to understand is that over the years, in all of the counseling that I've done, in all of the plan preparations and dealing with families and business owners, I believe that just one family crisis is going to affect 3 generations. And let me even articulate that just a little bit more. If we have a medical crisis, I don't care who it is, all of the resources, and the resources can include time, money, and physical efforts, are going to gravitate towards that person who has that issue or the medical need. Let me give you an example. Maybe you have a grandparent who has dementia, but also needs cared for. So the family time and resources are gathered towards that. Well, that affects the next generation and the next generation after that, because the resources that are necessary in order to care for that family member, they're not going to be available going forward, and we can wear people out. What if We have the matriarch of the family who has a significant medical issue. Pick one: cancer, something else, leukemia, pick something large that has happened. The resources will then go to that generation. Now let's go into the next generation, the grandchild. What if your daughter, she has twins? They both happen to be autistic. A lot of resources, energy, and planning is going to go there. So I firmly believe whatever happens in a crisis is going to affect 3 generations of your family. It's a reality. You don't have to like it. However, what are we going to do to plan around that so that it is not devastating to our family? So I'm going to start with your parents. Your parents' estate planning, or the lack of it, is going to make a huge difference to you going forward. It can make a difference on how much time you have to spend settling the estate, whether you've got to put money in to settle the estate, how the pieces are going to be distributed. And so it's very important that when we start talking about families and estate planning, I'm looking at what's the impact going to be for those 3 generations, wherever you are on that generational chart. The other thing we need to be realistic about, we need to talk about guardians for our children and for our disabled family members. Who's going to handle the day-to-day issues that are involved and the decisions that have to be made? What are some things that you may or may not have in place? Do we have Social Security? Are we going to rely on charity? What about guardians? Do the guardians need to have an income? What about savings? Do we have other family members that are going to be generous with their financial resources? Do we have unemployment insurance? Well, but that's only good for a certain period of time, and you've got to be willing and ready and able to work to qualify for the benefits if you're not working now. What about health insurance? Are you going to be able to qualify for private health insurance through the marketplace? Will you lose health insurance through an employer? Are you going to hopefully get on Medicaid, or are you going to be old enough to qualify for Medicare if you have enough quarters? Because work history comes into play there. Are you think that a lawsuit settlement is going to take care of all of this? Well, I've seen some pretty substantial lawsuit settlements shrink to a much lower number, because if it was structured so that it had to pay all of the medical bills, it had to pay all of the attorney's expenses, the attorney and the attorney's expenses, and whatever expert witnesses or whatever else was required. And by the time that the individual who was injured received it, that large award was much smaller by that point. Do we have trust assets set up? Are you planning on setting up trust assets? What about life insurance proceeds? Well, who are the beneficiaries? We don't want to have an incapacitated or a minor or a disabled person receive those proceeds directly, which goes back to, we need to have a special needs trust or a spendthrift trust or some type of trust set up to get those. I know I'm going to spend $5 on lottery tickets every week, and as soon as I win, that's going to solve all my problems. You'll have some new ones. Maybe you have other resources. What about, Medicaid assistance? Do you think that you're going to qualify? Not all states have the ability or the facilities that you may be looking forward to for long-term care or for other medical care. Oh, I know, I'm going to take it out of my retirement accounts, my IRAs, 401k. Well, how long is that going to last? Because all of those proceeds are taxable. So you're going to have to gross up or take a larger amount out of the accounts in order to pay the additional tax liabilities on those type of funds. Now, when I start thinking about what is the risk to an estate, the risk to the estate that it could be shrunk, or it could be depleted, or it could be liquidated because of various issues that maybe haven't been addressed, or they haven't been addressed in a realistic manner when it comes right down to the dollars that are used. So when I think about estate risks that we have to look at as part of the overall picture, what about the cost of long-term care? Has that been covered, or are we planning on liquidating assets? How long would that last? And I will tell you that a lot of people look at nursing home care only policies. I really believe that you want in-home health care coverage in addition to nursing home. Let's be blunt. Everybody wants to stay in their home just as long as possible, but we need to have the funds to support that. We don't want to force somebody to go into a nursing home because that's the only way that we can get the financial help. Are we going to require lifetime care, assistance, guidance for a disabled child or a grandchild? How do we need to set things up? Because if the primary caregiver dies suddenly, and it happens because many times caregivers, well, they're worn out. What is our backup plan for the next person who's going to step in, and how do we make that easy for them? You know, one of the other problems we run against on an estate risk is the families don't have the ability to act. Maybe you don't have a power of attorney with more than one person on it. So in case a person has passed away or is incapacitated themselves or simply doesn't want to do it, that we don't have to rely on the court to try and appoint somebody to handle the affairs. What is another risk? I will tell you it's geography. You may not think about geography as being a risk to your estate, but where are your family members? Where are friends, those different ones who would step in a crisis and would help? Sometimes geographic limitations are a problem where they are not able to uproot their life to come live with you or you to go live with them. If you own property that is outside of your home country, what are some of the estate distribution things that need to be in place there for those properties that you have holdings on? Maybe your family was from the Philippines. Do you still own land in the Philippines or family, estates or whatever? How's that really going to be distributed? What are the laws there? How does that impact if you are now living in the US? The same could be said for property in Portugal, Ireland, Uruguay. Pick a place. How do you need to coordinate that? Because geography could be a risk that you have to your estate. And of course, lack of planning. If you simply are not doing any of the planning, well, that's a risk to the value of your estate because it will get eaten up with fees and expenses. And if we have homes that are tied up in estates and there's no money to handle the maintenance and the repairs, how are we going to pay for the insurance? We can't legally rent it. What can we do here? So we've got to look at those type of things. This is probably one of the number one risks to your estate, in my opinion. You refuse to discuss the reality that you're going to die someday, or your parents are going to pass away, or your spouse is going to pass away, or your child is going to pass away. So we put off these conversations because we don't want to have them, but it doesn't make the issues go away. I'm going to step back for just a minute, and I want to talk and touch on just a little bit because there's a lot of confusion about long-term care and how long, a person might require long-term care. Some of the statistics are a little hard to come by because they don't do these all of the time. And as we're looking at some of it, I did find a chart from 2016 that there had been a pretty in-depth study. And in looking at 2016, of course, depending upon your age, that has an impact of what the odds are that you will require care. But it also has a difference depending upon your age, how many months you might require care. It may be a short-term issue where it's only for 3 months. It may be a little longer term where it's 12 months or 24 or 36. You might have a 5-year, but statistically, most individuals that have any type of a long-term care issue usually don't survive the 5-year mark. There are those who are not normal or not average and live longer. However, that's not the majority. So even in your planning, depending upon what your age bracket is, and I'm looking at this chart that happens to be in front of me now. And so let's pretend that you are ages 55 to 64. The odds that you will have a disability or something that incapacitates you for a period of 3 years is approximately 26.77%. That's about 1 in 4. You may not have felt that that really applied to you. Let's change the dynamics a little bit, and let's say that you are ages 75 to 84. If you are 75 to 84, and we are looking at an incapacity, a little over 52% of you are going to be incapacitated for 12 months. That's 1 in 2. So I'd like you to look around your room, look around your family, look in a couple. How many people are usually in a couple? Last time I checked, it was 2. Wow. Not very good odds, but this is an enormous threat to the estate that you have and planning that has to take place. What's another threat to the estate? Well, it's going to be your debts and your outstanding bills that you have. Do you have a home loan? What about unpaid medical bills? Do you have credit card balances? Do you have an unpaid lawsuit? Do you have liens? I mean, there's a variety of things that can be debt against the estate that has to be paid from the assets before those can ever be distributed to whoever you've named as your beneficiaries. So when I'm working with clients, sometimes I want you to step back and I want to ask you, what are you willing to do? Because everybody's a little different. Are you willing to spend absolutely nothing and you're willing to risk your entire estate? That's an option. Are you willing to use 2% every year to protect 95% of the estate? That sounds like a good trade. Maybe you're a little aggressive. You say, I'm willing to spend up to 5% of my assets every year if I will know and we can assure that 98% of my assets will remain intact. You have to invest in the result. Let's go another direction. Would you be willing to spend 10% of the estate now if it would increase it by 50%? Well, that's a little different idea, isn't it? What if you're looking at assets that you don't need, really? Would you be willing to use 20% of your assets to increase the value of the estate by 200%? I don't know. That's a personal question, but depending upon what your needs are or your desires are for your dependents or your survivors, there's a lot of different things you can do that can either protect the estate or can increase the estate, but it all comes down to whether you're willing to take action or not. Now, there's a common misconception that I see about a power of attorney at death. There are some individuals that are confusing the term power of attorney with executor. If you have a power of attorney, that is only good for the lifetime of the person who granted that to you. At the moment of death, that power of attorney no longer exists. Now, you could name the same person to be the executor of your estate or not, and that person would then take over and handle all of the issues within the estate to get that settled, to pay the bills, and to get public notices and all the things that are required to the point that the money is finally passed out to the heirs or the beneficiaries. So understand that a power of attorney is only going to help you while the person is living. An executor has to be in place or an appointed when it comes down to handling the estate matters. Is there a will that even names who the executor is? If not, well, what are we going to have to do? Well, you're probably going to have to take legal means to get that done. Now, one of the things that I really encourage my clients to do when you're drawing up these type of legal documents, it would be so very helpful if you would go what I call 3 deep. I have my first choice in the event that this person needs to step in, whether it's a power of attorney or it's my executor. That's my primary go-to. But if they have passed away or they simply cannot do it and they decline it, who is the second in line that I would want to take over? Same scenario. What if they are already deceased or they decline? They don't want to do it. Who's the third person in line? I might even go 4. I never want to have a judge have to determine who's going to be my power of attorney or an executor under those kind of conditions. It's going to be very expensive. It's going to be very painful, and there's no reason for it. The other reason, let's be blunt with each other here. If I can get some of you to even get the documents in place, you are not going to regularly look at these. How many of you who are watching this did documents, 5, 10, 20, 30 years ago, and you've never updated them again? So I'm going to encourage you to put multiple people on these. So if you don't ever get around to it, we still have a pathway of individuals that you have chosen to be able to hand those affairs for you. And that leads me to another point. If you have named someone or an alternate as your power of attorney or for your executor, do they have copies of these legal documents? Do you have these legal documents stuffed in a shoebox that is at the top of the closet that is underneath all of the other junk, and you haven't told anybody where it is? It's useless. Pass out copies. If you have it stashed in a bank safety deposit box, I'm a real human like the rest of you are. It's a bank safety deposit box. Well, who has access to the box? If it's only you, nobody else can get in there to get to it. So let's think about empowering the people you've named by giving them the documents. Now, there are some of you who go, what? I don't want anybody to know what's in it until it's time. Okay. Well, let me give you an inexpensive way that I've seen some people do it. You may come up with another method. You know what an envelope is, and the envelopes have the flaps on them. I've known individuals that have taken the envelopes and they've used a marker or something else, and they write their name, or they do not open until I die, across that flap. Periodically ask for the envelope. If they have opened the envelope, you're going to be able to tell. So that is what I will call a poor man's way of doing it. There are other ways that you could do it, but that's something to think about, is empower the people you've named to have the documents that they're going to need: power of attorney, medical power of attorney, estate documents, those type of things. Make it easy. Don't make it any harder. Now, who should you have copies of documents from? Well, I just told you that if you were named, that would be an ideal situation for you to have copies of them. Whether you should look at them before you are tasked or not, that's really up to the individual. I really believe in open communication, because if you're naming someone to take care of whatever these tasks are, we need to know they're competent, or we need to give them the authority to hire professionals to help them. So you probably want to share what's in the documents with them, at least so they know what you are asking them to do. And if you do ask a person and they decline, that's fine. Get someone else. They're being honest with you up front that this is not what they feel capable of doing. So who has the legal documents that are in good order and they are current for your grandparents? What about your parents? Do you have aunts and uncles? What about your siblings? How about your adult children? And in many cases, I will tell you, because we have got a lot of young people now that have YouTube channels, they've got businesses, they've got a lot of digital type assets. They may not be 18 yet, and they need estate plans because of the businesses and the enterprises they already have. Now, if you are very close, you might have some that are with church family members or friends that you're close to, because maybe you're very close with your friends, their kids are close, you guys are just like, you could have been brother and sister, you get along so well, but you have families that are halfway across the country. So maybe the best thing for you is to name those friends who are so close and they know you. That's going to be a personal decision. I will tell you that you should always remember that there are two partners in every estate, and one of them is death and the other one is taxes. They will both come into play here at some point, but you have a lot of control over the taxes part. Death, sometimes you'll get a warning that this is coming, but not always, but the two will always hold hand. And one of the responsibilities with the estate is there is an estate tax return that has to be filed within 9 months, and the taxes paid 9 months of the decedent's death. And of course, they're also going to have their income taxes filed for that last year they were living. So for example, if taxes were due for the prior year by April 15th, and they died in January, their taxes still need to be prepared and they still need to be turned in. That does not disappear. We've touched on the word probate. Now, probate is a process. It's a very public process. It's a process where basically everything you own is put together, and then everything that you owe is deducted from those assets, and your attorney fees and appraiser fees and whatever fees go along with this, and court costs and whatever happens in the process, so that at the end, when everybody has been paid, everything is a matter of public record, then those assets will go to whoever you have named as your beneficiaries and your heirs. Remember what I said in the beginning? In my perfect estates, we don't want to have any assets that need to be probated because we have taken care of that distribution and we don't need the probate process to do that. How can we do that? Because we have so many different assets. Well, your ownership matters on how you title these assets. It makes a difference on titling your assets now, often for tax purposes or in the event of a divorce or anything, incapacity. There's a lot of different reasons, a business partner. It also makes a difference later when it comes time to pass out these assets or to distribute them or to sell them. So you can have assets that are owned individually by one person. You could have JTWROS, that is joint trust with rights of survivorship. With that one, very simply, we have, let's say, two people who own this property. Both of us have an equal interest. The first person dies. The second person inherits or receives all of that property. You could have tenants in common. That's a different scenario. I own an undivided 1/2 interest in that particular situation with two of us with tenants in common. At my death, the other person does not automatically inherit that property. It may happen through a will or through a trust, but it's different because the titling is different. There's an impact with that.